On March 20th, 2025, Byron Laws appeared before Judge David Fleischer in the Harris County Criminal Court in Houston, Texas. He was charged with driving while intoxicated with a reported blood alcohol concentration above 0.15, stemming from an arrest on October 5, 2021. The case remained pending. At the hearing, Mr. Laws was represented by newly appointed defense counsel Anna Eady, who asked the court to reconsider whether probable cause existed for the warrantless arrest after reviewing the case file. Ms. Eady relied on established constitutional law, citing Gerstein v. Pugh 1975, in which the U.S. Supreme Court ruled that a defendant arrested without a warrant is entitled to a timely judicial determination of probable cause. The court held that a prosecutor's decision alone is insufficient and that probable cause must be reviewed by a neutral magistrate. Texas law reflects this requirement. Article 14.06 of the Texas Code of Criminal Procedure requires that a person arrested without a warrant be brought before a magistrate without unnecessary delay and no later than 48 hours after arrest. Although a probable cause determination would normally have occurred at the time of Mr. Law's 2021 arrest, Ms. Eady asked Judge Fleischer to reconsider whether probable cause truly existed in this case.
I'm approaching on Laws.
Okay.
Is the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right. This is
You don't think there's PC?
Laws.
No.
Yes.
You don't think there's PC?
I don't, looking at the DIMS, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So
Did you already approach on PC on this?
I have not.
Don't worry about it.
I'll just be honest, Judge. I had assumed because of the age of the case that PC had been done. But
Of course it has been.
right.
But there's a new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through it. 2021 case. On October 5th, 2021, the officers were dispatched to a DWI call. The officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes as well as making a U-turn on the highway, hit traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, odor of alcoholic beverage, and poor balance, and a cortical with quiet, please, hold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walking turn, and a 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, but I mean, what's...
But I thought for PC, we just used the DIMS because that was sworn to and not getting into the.
Show me where it says that. I don't know of any rule that says that it's PC has to be done on just the DIM.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and
never.
that just may be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything where someone has ever directed me to saying, "Hey, PC is only
Well, it's
has to be just on the DIMS." You
because
know.
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into
Sworn document too.
the offense report's on a sworn document.
I mean, I guess, Your Honor, my thing is it's a public record that they're using the DIMS taking the offense report. And also, I have never seen it before where we have to rely solely on the DIMS for probable cause. It's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look, because I don't know, you know.
Okay. I'll stand
And
down.
I'll
Go check with
sure.
Ms. Rogers.
Ms. Eady argues that a probable cause determination must be based solely on the allegations in the DIMS, not on the facts contained in an offense report. DIMS, or the District Attorney Intake Management System, is the electronic system officers use to submit charges to the Harris County District Attorney's Office. When a person is arrested without a warrant, the arresting officer contacts an assistant district attorney to assess probable cause. If the charge is approved, the officer completes the DIMS submission, which includes officer and defendant information, charge details, and a required summary of facts. The DIMS manual requires this summary to briefly explain who, what, when, where, and how the alleged offense occurred. This summary is used to establish probable cause for a warrantless arrest, and the manual expressly states that references to an offense or arrest report are not permitted. Officers must include all essential facts, and once submitted, the DIMS cannot be altered. An offense report, by contrast, is the formal police narrative prepared after the arrest. It contains detailed observations, witness statements, and test results, and may be supplemented as the investigation continues. Ms. Edie maintains that because only the DIMS may be used to establish probable cause, and because the DIMS in Mr. Law's case lacked sufficient detail, probable cause for his arrest was never properly established.
So you're saying that the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to.
okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIMS summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations, because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation. So I think it is a Fourth Amendment issue.
I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
well, the four corners of the DIMS is what's sworn to, the offense report is not.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the office report, he is committed a crime. So, I mean, I don't say that the office report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false,
Right, but perjury's
an official document?
a different crime.
No, but it would also under the purview of filing a false,
Well, Judge, if an officer came into court and was asking for you to sign a search warrant and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest, it was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
Was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
if you're on the case level.
Huh? Okay,
If it's okay with you, we'll take.
can you show them?
Yeah, that's fine. Yeah.
Miss Edie and her colleague reference a class action lawsuit concerning probable cause determinations in Harris County. The case, Liss versus Harris County, was filed on December 28, 2016 by attorneys from the Civil Rights Corps and the Texas Fair Defense Project. The complaint alleged that Harris County violated the Fourth Amendment by detaining arrestees without a probable cause determination by a neutral magistrate based on sworn facts. At that time, the DIMS report used to establish probable cause was not a sworn statement. The case was settled on November 1, 2017. Harris County did not admit to any Fourth Amendment violations, but the district attorney agreed to change the process for warrantless arrests. Officers would now swear to the facts they enter into DIMS. Under the settlement, each time an arresting officer inputs arrest facts into DIMS, they must check a box declaring, under penalty of perjury, that the information is true and correct to the best of their knowledge. In short, the DA agreed that sworn statements from DIMS would now be used to establish probable cause.
Anna, you ready?
Yes, Judge.
Mr. Laws, come up. We have court orders for a reason, and when you don't follow court orders, bad things happen. Do you understand? Yes. You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right, good luck.
Thank you, Judge.
We were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, I want to stick with the agreement that the county came to with the district attorney's office,
Not saying it's this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because you might get like 15 supplements.
Here's my question then for the court, and I'm not saying I'm gonna do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, that say we can't take it to grand jury?
You can, of course you can.
So,
Yeah.
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah,
As
and
far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
I'm just, and this is for my own.
And you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you, Judge.
Oh, really?
So we wouldn't be held to that same standard at grand jury.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like
Absolutely.
she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is,
This is required to
I understand.
which is good.
Thank you.
God love you.
Judge Fleischer ruled that there was no probable cause to support the charge based on the sworn facts in the DIMS report, as required by the Liss versus Harris County settlement. However, because Mr. Laws was charged by information, a charging document filed by the district attorney, Judge Fleischer noted that the prosecutor could still seek an indictment from a grand jury. In Texas, a grand jury consists of 12 citizens who decide whether there is enough evidence to formally charge someone. During these proceedings, governed by Chapter 2A of the Texas Code of Criminal Procedure, the prosecutor presents evidence and calls witnesses under oath, usually police officers or complainants. If at least 9 jurors agree that probable cause exists, they return a true bill, creating a formal indictment. If not, they issue a no bill and the case does not proceed. Here, Judge Fleischer's ruling meant the current charge could not stand due to the deficient DIMS report. Nevertheless, the district attorney could have pursued a grand jury indictment. After the ruling, the state moved to dismiss the charge against Mr. Laws while reserving the right to refile. The court granted the motion, formally dismissing the case. As of this writing, Harris County prosecutors have not refiled the charge. This case underscores the importance of accuracy, transparency, and adherence to constitutional procedures. Probable cause statements and their review by prosecutors serve as a critical safeguard for defendants' rights. The Fourth Amendment requires that charges rest on properly sworn facts and an independent judicial determination of probable cause. These are not mere technicalities. They prevent unlawful arrests and protect public confidence in the justice system. By ensuring each case starts on a lawful, well-supported foundation, officers and prosecutors safeguard both defendants' rights and the integrity of the judicial system. Let us know in the comments if there's a case or courtroom interaction you want us to cover. Thanks for watching, and don't forget to subscribe and share to help foster a more informed society.